I'm Gary Feldman.
I'm Tamsin Kaplan.
So we're David's Malm. We're two of the lawyers in the employment group. Welcome to our presentation on some new developments in employment law.
You get a complaint from an employee. It might be just an informal complaint, nothing formal, nothing in writing, that leads you to the conclusion that there may have been some unlawful sexual harassment, say in the workplace. What do? You are immediately required to respond, and the response must be prompt, and the response must include an investigation of the allegations. There should be some temporary remedial measures put in place so that the alleged perpetrator and the alleged victim are comfortable in the work environment. Sometimes it makes sense to put the alleged perpetrator on a paid administrative leave. Sometimes it makes sense for there to be some kind of a separation physically in the workplace. One thing that I see employers doing a lot in this situation is saying, hey, you two get together in a conference room and let's all chat about this. We don't do that because the nature of that kind of an allegation is that there's an unlevel playing field and that there's somebody who is feeling harassed, intimidated, uncomfortable with the other individual. So what does that investigation entail? You need to have a neutral investigator. All of the facts need to be investigated. We do this with interviews of everyone who's involved or who might have had some observations that would be helpful in determining what really happened. Oftentimes it's difficult to do this with an in-house investigator because you're the HR person, you interact with these people every day, you may have some preconceived ideas. Also, let's be honest, as the HR person, you may tend to view this more favorably to the employer, i.e., you may want to make sure that there's no liability. In Massachusetts, if a manager or supervisor is responsible for unlawful discrimination or harassment, the employer is automatically liable, automatically on the hook. So oftentimes, depending on the situation, you might bring in an independent investigator. Regardless of whether you do the investigation with an in-house person or with an investigator from the outside, the process has to be squeaky clean, because should there be some discipline or termination that arises at the end of this investigative process, you want to make sure that you're not going to be liable because something went wrong in the investigation. So say, for example, someone complains about sexual harassment. You decide that there was no sexual harassment and that in order to address the situation, you're going to move the employee who complained to a different workstation or to a different location. If that employee perceives that that's a less desirable location, they can allege retaliation. I made a legitimate good faith claim, I engaged in protected activity under the statute, and you adversely affected my employment. You took some kind of adverse action against me. Flip side, you may have problems if you are hasty and terminate somebody who is an alleged perpetrator who feels that they were innocent. So very tricky. What we do when we interview witnesses is we make sure that they understand that their participation in the investigation is protected. They cannot be retaliated against for participating in the investigation. And frequently until recently, we were advising employers that in the course of the investigation, you should require that all employees interviewed maintain complete confidentiality. Okay, now why has that consistently and traditionally been our advice? Any ideas, Misty?
To just protect everyone who's involved.
Sure, to protect everyone who's involved, to not have the matter get worse. I mean, sometimes if there are a lot of rumors in the workplace, the person who complained may feel vilified, marginalized. The person who was complained about, similarly, may feel that they're being treated unfairly. However, the NLRB, our favorite National Labor Relations Board, came out in a recent decision called Banner and said that no, you cannot across the board advise or instruct people who are your witnesses that they must keep the substance of the conversation, the substance of the interview confidential. You can tell the way I feel about this. However, there's a way around it, because this case laid out findings that you can make in advance of the investigation or in the advance of particular witness interviews that will allow you to give the instruction of complete confidentiality. And my opinion is that you can always make these findings, but you just have to go through the motions. You or your independent investigator have to make sure to go through this process of determining that one or more of these risks exists, document it, and therefore justify this confidentiality instruction. So you have to find, by the way, everything I'm referring to are in the email alerts that are in your materials. Gary and I, on a regular basis, do these email alerts to all of you and our other clients when new issues arise. So over the last couple years, we've done a fair amount of the material that we're covering today. Okay, so you have to find that there's a need for confidentiality to protect a witness, that there is a need for confidentiality because of a likelihood that evidence will be destroyed if you don't maintain confidentiality, that there is a threat that testimony from a witness might be fabricated if people have advance notice and they know what's going on and they're hearing what you're talking to other witnesses about, or 4, there's a need to prevent a cover-up. Now, I mean, it seems to me these are exactly the reasons why we always instructed our witnesses that confidentiality is necessary. But now we have to make sure that we make a finding, and I recommend that you document it, put it in your investigation file, so that you can then instruct everybody about confidentiality. Now, just a few words of advice about investigations. I recently concluded a 5-month investigation, and I talked to 110 witnesses. It was a huge investigation. Some people in this room helped me with it. And one of the key things is extremely careful either note-taking or taping of conversations. I do not like taping. I think that makes people uncomfortable. You have to have their consent in Massachusetts, of course, to tape them. I suggest instead you sit there with your laptop and take very good, thorough notes. Or if it's a key witness and you want to maintain eye contact and you want to be 100% focused on the witness, have a second person in the room with you, an HR assistant, or in our case it was me and one of our other lawyers here, taking notes. You want to be sure to keep extremely careful documentation of your investigation. Again, neutrality is key. At the end of the investigation, both the alleged perpetrator and the alleged victim have to be informed of the results of the investigation. I recommend that there is always a report that goes in the investigation file. And of course, prompt remedial action is absolutely required by law if there is a finding that there has been some unlawful conduct. Final word of advice, and this is the most important thing I will tell you if you're ever doing an internal investigation as an employer, never find that there's been sexual harassment. Now, what do I mean by that? What I mean is, never in your findings do you need to say, we have concluded that as a matter of law, sexual harassment has occurred, because that would be an admission and you are automatically going to be liable if you're the employer of the supervisor who you just concluded broke the law. So what we say is, we have concluded that there's been a violation of our policies. Same thing, just be really careful what words you use when you're making conclusions in your report. If you've concluded that there's a violation of your policy and you've concluded that appropriate remedial measures require possibly termination of the person who caused this problem, that's fine. But I just advise you to be careful with the language you use. You don't want to put something in writing that is going to come back and bite you. Chris?
Following up on that point, a couple of days ago I mediated one of these cases. It was a sexual harassment case. And the HR department's file was completely useless because they may have orally received information, but the documentation was just not there. And Employees Council had a field day because people involved in the investigation from management's side, some were no longer at the company, some hadn't written things down. So the documentation is crucial.
Thank you. Chris is a wonderful mediator. I've mediated many cases with him. He's very talented. And he gets to see both sides of all these cases and what, 90-something% of the time settle the cases. So he has tremendous insights from the perspective of a neutral.
And nobody knows what really happens. It's perception. And if the file is thin, and if the only people involved in the investigation are supervisors or direct supervisors or best friends of, it's just not good for management.
When I know that oftentimes it's expensive to bring in an outside investigator, and you're not going to do it for every case, but I would certainly suggest that you seriously consider bringing in an outside investigator when the person against whom the allegations are being made is a high-level person in your company, because it is very difficult for an HR director or an in-house person to do a fair, neutral, open-minded, impartial investigation of their boss or of the COO or the CEO of the company or the executive director of the company. So just keep that in mind.
And keep in mind, not that it would change your course of action, but typically that investigator's file is not treated as it's not privileged, is not treated as attorney-client.
Right.
So it's not an attorney-client file. So if the matter moves from an internal investigation to a judicial proceeding, whether at the MCAD or in state or federal court, that investigation file and everything in it will likely be subject to discovery.
And your investigator will be a witness.
Right. So where, when that situation comes up for a regular client, and if I'm asked to investigate, one of the first questions I would ask is, okay, well, if this goes into litigation and we're your regular outside litigation counsel and we do the investigation, I wouldn't be able to do both. I wouldn't be able to investigate the matter, and then if the matter were to go into litigation, I wouldn't be able to be your outside litigation counsel. And so you don't have that particular issue if you're conducting an investigation in-house or internally, but just keep in mind that your investigation file is subject to discovery if it results in litigation.
And you're not going to use your lawyer to be your investigator. Your lawyer will help you find another person, an appropriate person. Oftentimes another lawyer from another law firm. That's oftentimes how I get pulled into investigations, is a lawyer from another firm actually brings me in to investigate in a workplace that is his client's.